Hey everyone, here at the Begin Sports Network, I've been following the Brandr Group lawsuit against EA with regards to NIL and who can negotiate with the players for the new college football video game that's due to come out in the summer of 2024. Well, just saw an article that dropped actually yesterday that the Brandr Group, they're not going to go away. They're filing a new complaint against EA in an attempt to stop EA from negotiating with players and Brandr's clients. So let's get right into it. Let's talk about this article and see what is going on. So this article, I'm actually reading it from Yahoo Sports, but they have actually gotten the article from a website called Sportico, written by Michael McCann. Uh, Yahoo, they're like one of those aggregators of news, and so that's why I'm able to read this story. If you go to Sportico's website, they ask you to log in to actually read it, but here on Yahoo Sports, we can actually read the full article itself. So you can see here the title, Brandr swings again at EA as legal fight over video game NIL heats up. The Brandr Group hopes to bolster its federal lawsuit against Electronic Arts over the inclusion of players in schools' names, image, and likeness in EA's first college football video game since 2013. Once again, college athletes are bystanders in a legal process where their right to pay is at stake. Okay? So, in a California court last week, Brandr filed an amended complaint in opposition briefs to EA's motion to dismiss and stay discovery. In June, Judge Haywood Gilliam denied Brandr's petition for a temporary restraining order, noting that there is simply no evidence in the record that the value of the students' NILs would be diminished by their use in the game. And remember, this is very important to understand. All that's happening with the Brandr Group, and the Brandr Group's there to help student athletes with their NIL deals. Doesn't necessarily mean that they're the ones who are totally negotiating all the time for the athletes. So the athletes can get their own NIL deals as well. It's just that the Brandr Group's there to help them with that. With the schools, they have their own licensing organization, and so it's not really. So the schools is not an issue with the Brandr Group because the schools themselves have their own way of licensing. Okay. Brandr, which says it has an agreement with 65 colleges with NCAA football programs and with 3,735 players, insists it has the contractual right to represent schools and players in negotiations for inclusion in EA Sports college football. Remember, this is part of the argument that Brandr's making, but we have the CLC, College Licensing Corporation. Basically, that's who's licensing the schools. I wouldn't say that that's a really strong argument, but that's what the Brandr Group is going with. The NIL agency wrote that most of its contracts specifically identify video games and call for athletes to receive 70% of royalties from third-party licenses in video games and trading cards. Brandr claims EA unlawfully interfered, including by, as Brandr tells it, communicating to schools that they do not need to honor the exclusivity provisions and that it is not a violation of Brandr's rights for EA to contract directly with college players. Brandr also criticizes EA for a plan to pay each athlete just $500, saying that amount is well below market value for the use of their NIL in the game. Brandr compares that figure with what it has heard from partner schools. EA is allegedly offering to pay schools 10% of the game's revenue and guarantee payments ranging from $10,400 to $104,900, depending on variables such as the football program's prominence, recent national ranking, etc. Okay? That makes a little bit of sense because remember, you have to understand there's a lot of tie-in, not just to the players, but more so to the school. So I'm not surprised that EA may pay the schools more. And what you're seeing online is a lot of people are talking about, hey, just give us the schools and generic rosters. We just want the schools. We want the schools in the game. We want to take that University of Texas San Antonio and make them a national champion. That's what we want to do. And so I'm not surprised that they may be paying the schools more. But who knows what's going to happen. Brandr also criticized EA Brandr further warns that based on its understanding of EA's strategy, schools will grant exclusive rights to EA to use their trademarks and related IP. That arrangement would preempt rival college football video games that could lead to more licensing opportunities for the players. Ooh. So there's where Brandr's saying, hey, players, there may be more college football games. And for those of you who are too young to remember, there was a point where there was 2 college football video games, one by 989 Sports and then the EA one. Now 989 Sports eventually stopped doing their college football game. I think they folded, but there was actually 2 NFL games. Madden and 989 had sports had their own NFL game. I think there was actually 1.3 NFL games and 2 college football games. So that's a very interesting argument. I don't know if it has strength. EA has rebuked these arguments in court filings. Most crucially, EA says it has the right to negotiate with schools and athletes, and that Brandr is outside this bargaining relationship. The video game publisher contends that Brandr can't retroactively change individual contracts EA or its licensing collaborator, one team partner negotiates into a group license that Brandr controls. EA's approach to licensing isn't unusual. A contract of adhesion or take it or leave it approach where a player can accept $500 in exchange for the NIL to appear in the game or decline and not be in the game is generally lawful in licensing and other types of transactions. EA is the offerer. It can decide what it deems appropriate, fair, or profitable. A player is under no obligation to accept the offer. While $500 might seem low for star college football players, it might seem high for lesser known players. And this is the issue, right? This is always the issue with these types of deals, NIL rights and things like that. You have big name stars, and then you have the guy who's the 4th-string player on a team or a walk-on that never really plays, but he's on the team. How much should they get? The $500, is it fair to someone like say, Caleb Williams was still playing college football? Everybody knows he's coming out next year. But let's say that he was in the game. Should he get more? Well, I would say yes. Especially what if he's the cover athlete? Well, then, yeah, he probably should be making more. So what's the question? And I think this is where royalties might come in. Maybe there should be some negotiations of royalties. You know they're going to put Ultimate Team in the game, folks. Wouldn't be surprised if Ultimate Team's in the game. EA just can't help themselves in that regard. So if they do have Ultimate Team in the game, maybe you have to give royalties based on, hey, this is how much money people are buying these packs, things like that. I don't know how it's going to happen. It'll be interesting to see. But yeah, this is a very interesting. Basic economics also apply. If EA finds that $500 isn't enough to convince enough players to sign, it can offer more. No law compels EA to offer a certain level of compensation, and no law guarantees a player a right to be in EA's game. This is fundamentally a private transaction. This debate, EA's ability to control the terms offered to players and Brandr's assertion it controls those negotiations is a byproduct of the current state of college athletes' rights. College athletes haven't been recognized as employees, which under labor law means they can't form a union. In contrast, players in pro leagues have unionized, and their union is their bargaining agent, giving pro players considerable power in negotiations. And this is where I think we're going to be heading, guys. There has to be a union at some point for college athletes. This is part of the problem. This is one of the differences, when the Brandr Group's like, well, you're paying pro players all this money for their rights to man. Yeah, well, first and foremost, there's fewer players in the NFL, but they also have a union, and that union has negotiated these rights. Those rights are not being negotiated by anybody but the players themselves. So each player is kind of negotiating their own rights. What you would prefer, if you were really honest, if you're a player, is to have some kind of union. And that's why one of our first videos, there's now trying to be a college football players group that's trying to create a union for college football players. Are they going to be successful? Who knows? But that's what they're trying to do, okay? The Brandr EA legal controversy also reflects the peculiarity of college sports, where the labor who drive a multi-billion-dollar industry are largely dependent on others' negotiations. The dynamic could change, though, probably not soon. Later this year, and this is something that people are not paying attention to, an administrative law judge could find that USC, the Pac-12, or Big Ten, because the Pac-12 is basically in trouble. I don't know how much it's going to really exist in a few years, or next year, or 2 years, or anything. And NCAA are joint employers of Trojan football and men's and women's basketball players. Now, that's something that California has been pushing forward to make athletes of men's and women's basketball players, football players, they're actually employees of the school. The NLRB could uphold that finding, and appellate courts could do the same, but even if that multi-step sequence concludes with the recognition of college athletes as employees, the sequence would take several years and not resolve before EA's game is released, Johnson v. NCAA might produce college athletes as employees, but the litigation is similarly posed to take years. Power 5 conferences could consolidate and form pro leagues where the players are employees and negotiate their rights. But the first mover in that scenario would be conferences and member schools, not the players. Congress could theoretically make a plan. Excuse me. Congress could theoretically pass a law making college athletes employees, but it hasn't been able to get a much less controversial narrow topic, NIL, to the floor for a vote. So as the Brandr EA battle plays on, the athletes might have a front row seat, but they won't be in the game. And I think this is really important to understand. It gives an idea of what the Brandr Group's fighting for. Again, I don't know if their argument is going to necessarily hold. Um, I think EA's case is stronger based on what I've been reading, based on hearing from two, the Boise State professor who has talked about this lawsuit before, and then Richard Hogue, who is a video games lawyer. They both have said that the Brandr Group's original injunction request was weak. I don't know that the Brandr Group is going to be able to really prove what they're trying to with EA. It's going to be exciting. We're going to find out soon. The case goes to court in September and October, and this is where we're going to find out the truth. Anyway, guys, this has been just quite the saga. We're going to keep following it. Again, we were not going to hear more really about the compensation for players until spring of 2024. That's after all the transfer portal issues, all the transfer portal is done, where athletes have gone to different schools. You have signed your new classes, so you know who's going to be exactly in the game and where. And, you're going to have players that are going to show out this coming season that will be back for the next season. So it's going to make things exciting. I hope that they get this result. I actually have high hopes for this game. I've been playing college football on the revamped. We also have a dynasty going up on the original 360 version of NCAA Football 14 of the Cupcake Academy Cupcakes. It's 11 overall school that we've been building up. But stay here. Make sure to let me know what your thoughts are down below. We'll have a link to all the videos that we've made regarding the Brandr lawsuit, all the issues with NIL and EA college football. My name's Big Ian. You guys have a good rest of the day, and we'll see you next time, in the next month or so, when we find out more about this lawsuit between the Brandr Group and EA. Have a good one.